Hi, I'm Sarah Einowski, an estate planning attorney at Tonkin Torp. We're a Portland-based business law firm, and I'm licensed in both Oregon and Washington, here to help with any of your estate planning needs. Today, I'm here to talk about what happens to your stuff when you die. So during life, we have two buckets of assets. One's called probate assets, and one is non-probate assets. The probate assets have to go through what we call probate. You may have heard of that. So probate is a court supervised process where you take the assets of a decedent and say to the court, hey, this person has died and we need to transfer these assets to somebody else. Now, whether that's if they have a will, then it goes via the will. If they do not have a will, then it's through their intestate heirs, or it's whatever the state tells you your estate plan is. Non-probate assets, by contrast, pass by operation of law. So what you do is you show up with a death certificate, you say, hey, this person has died, and the bank or the retirement account or the life insurance policy says, okay, here you go. So examples of non-probate assets include anything, some of those examples I just gave. Retirement accounts go by beneficiary designation. Life insurance goes by beneficiary designation. Typically, spouses own their assets jointly. So if you have a joint checking account with your spouse, or you own your house joint with rights of survivorship, then when the first spouse dies, the surviving spouse gets those through operation of law. There's no reason to go to court. Examples of probate assets include a checking account that you hold in your own individual name, or if you own your house in your individual name, anything that is in a single name, you need to then go to court and say, hey, this person has died, and transfer the assets via the court supervised process. How does this affect your estate plan? You may have heard there's a difference between a will and a revocable trust. A will is what happens to your stuff on your death. And a trust can also be that testamentary document that tells you what to do with your things on your death. A trust is essentially a bucket that holds your property. And the bucket doesn't die when somebody dies, it goes on. So the post-death administration happens within that bucket, and there's no need to go to court. Now, if you have friends in California, you may hear that they have a trust. A lot of people in California typically have a revocable trust, because California probate tends to be very time-consuming, expensive, and just cumbersome. So everyone, not everyone, but a lot of people in California have a trust. Here in Oregon and Washington, probate's not that bad. It takes about the same amount of time and can cost similar amounts to a post-death administration within a trust. So doing a trust in Oregon or Washington simply for the benefit of avoiding probate is not always necessary. There can be other reasons for avoiding probate. For example, if you own a house in Portland and real estate in White Salmon, Washington, you have a vacation home in the Columbia River Gorge, then you may want to trust, because as fun as probate is, you don't want to have to do it in two different states. So in that case, we may want to trust to hold your property. If you have any other questions about estate planning and your estate planning needs, please feel free to reach out to any of us at Tonkin Torp or me directly. My information's there on the screen, and I look forward to hearing from you soon.